Hello, welcome everybody. Welcome. Hello. Hello, welcome. Good to see you all. Hello, hello. I should have my comments off, everyone. Let's see. Are my comments off? They should be. Oh, goodness gracious. Oh, they're not off. Hold on, Suze. Sorry, everybody. I got it. I need to turn my comments off. Forgive me, everyone. I do plan to have comments off while I just read through this. I've got the closing statements here, so hold on just a minute, everybody. I know, right? I know. I'll figure it out one of these days, everybody. Oh my gosh. All right. So just a minute. Here we go. All right, here we go, everybody. I will turn my comments on for a Q&A as soon as I finish reading. I will be just diving straight into the reading. So there we are. Comments are off so we can have a peaceful reading. Welcome, welcome. Oh my goodness, sorry about that. Happy Saturday, everybody. All right, well, welcome in, welcome in. We still have quite a bit left of the transcripts, everyone, to go through, and I do plan to continue to go through those. So I am going to read through Mr. Blanche's closing statement. I have read through a little bit already. I did want to pick up where I left off. So I will read his closing statements, and I'll probably read for about an hour. We'll see how far we can get. I think we can make it pretty far. And then after that, I will turn on comments. We can do a Q&A at that point in time. But I think it will be better for us to have comments off so I can get through the reading without missing anybody's important comments. So thank you all for joining me today. I really do appreciate it. So let's go ahead and dive right in then to the reading. By the way, I also do have the transcript from the verdict as well, so I will kind of go through that during our Q&A as well. But for this particular live, to get it started, I do want to start reading through Mr. Blanche's closing statements. So for those of you who were with me when I was reading Mr. Blanche's closing statements to start, we were able to make it through a few pages. So we started on page 4455 here. These are the transcripts again from the New York case. And at the very top, you'll see what it is that we're going through. We've got the summation here for Mr. Blanche, and this is right here where I left off last time. So I will pick up on line 4. And again, for anyone who is interested, what we are reading through is labeled right up here, and who's speaking is up here as well. So welcome in. I will just pick up where I left off, and again, I will turn on questions and comments after I do finish reading. So thank you all for joining me. All right. Again, this is Mr. Blanche's closing in the New York case. Now, when the government talks to you about these invoices, Mr. Cohen, as I expect they will later today, and uses the phrase, for services rendered, what you see on the screen, that's a true statement, period. And that's not evidence of some secret agreement that Mr. Cohen had with President Trump. He broadcast this fact to the world. Remember, he told you that after he had a meeting and it was established that he would be the personal attorney to President Trump. He rolled right into Sean Hannity. He talked to every reporter that he could, pushing the fact that he was going to be the personal attorney to Mr. Trump. He put that signature block on every single email that he sent in 2017. This was not a secret. Michael Cohen was President Trump's personal attorney, period. Now, I talked a little bit about the retainer agreement a minute ago, but many of the invoices also talk about retainer agreements. Now, remember what Mr. Cohen said to you about retainer agreements and whether there was going to be or ever expected to be a written retainer agreement between him and President Trump. The testimony is on the on the screen. Question. Correct me if I'm wrong, there was never an expectation that there would be a retainer agreement, right? Answer, correct. That was a lie. And you cannot just minimize the lie and say, well, maybe he made a mistake. A lie is a lie, and this is a significant lie. Remember the email B206. He was not shown that email on direct examination. This is an email sent by Mr. Weselberg to Mr. Cohen as soon as he started as President Trump's personal attorney. And what does it say? Thank you. You never stopped in for a bro hug. Please prepare the agreement we discussed so that we can pay you monthly. How can it be that Mr. Cohen repeatedly asserted on direct examination, and even on cross, there was never going to be a retainer agreement? Now, it was a big scam to cover up a payback. Did they forget to tell Mr. Weselberg about the scam? I mean, is that what Mr. Cohen wants you to believe? Absolutely not. Now, the invoices continue to talk about retainer agreements. And remember, Mr. Weselberg was clear. He asked for a retainer agreement, asked for him to see it. You didn't see a retainer agreement. There is no evidence that there ever was one put together. But as you know, as you heard from multiple witnesses about that, it doesn't matter. Objection sustained. As you know, the fact that there was a verbal retainer agreement between Mr. Cohen and President Trump is consistent with the practices of another lawyer you have heard from. Objection overruled. Mr. Davidson, Keith Davidson. And you can see what Mr. Davidson said in response to questions about that. There's nothing wrong with that, meaning there is nothing wrong with the retainer agreement he had. Objection. The objection is overruled. Beyond Mr. Davidson, remember Mr. McConney, who is not a lawyer. He just works for the Trump Organization. He told you the same thing regarding retainer agreements and verbal retainer agreements. By the way, ladies and gentlemen, there is no dispute that in 2017, there was an attorney-client relationship between Mr. Cohen and President Trump. Nobody has told you differently. He, meaning Mr. Cohen, was President Trump's personal lawyer, period. So before we get to the vouchers, let's just take a step back. Nobody disputes that Mr. Cohen was President Trump's personal attorney in 2017. So what makes more sense? What makes more sense? That President Trump was paying his personal attorney in 2017 $35,000 a month pursuant to an agreement that President Trump made with his personal attorney right before he took office? It makes perfect sense. Or the version that Mr. Cohen came in here and told you, which is that no, I was not paid. I was going to work for free. Now, I didn't tell anybody that, but in the back of my head, that's what I thought, is I will just work for free and make a lot of money as a consultant, and the $35,000 a month is not really for my retainer fee. It's actually an overpayment for the $130,000 that President Trump was paying me back because of the NDA. For the first time in President Trump's life, he decided to pay me back triple. He doubled up the $130,000. He gave me $50,000 for some online poll that he had decided he wasn't going to pay for over a year, which, by the way, I stole from him a little bit of that and decided I wanted a bigger bonus. So I got an extra $60,000 on the bonus. That's not what really happened, ladies and gentlemen. There is a reason why. There is a reason why in life, usually, the simplest answer is the right one. And that's certainly the case here. That the story that Mr. Cohen told you on the witness stand is not true. That really he paid $35,000 a month by President Trump to be his attorney in 2017. Now next, let's talk about the vouchers. There are 12 of them, as you know. There are 12 vouchers that are at issue in this case. In this case, I put one of them up on the screen for you to see to remind you. And again, this is from the Trump Organization's MDS system, as you heard about from Mr. McConney and Ms. Tarasoff. Remember, Mr. McConney told you that it was an antiquated accounting system back in 2017. But also, and significantly, there is no evidence that President Trump knew anything about this voucher system. No evidence, not a single word. Now, I don't know how the government's going to address that, but let me tell you this. If the government reads to you, quote, from a book a decade earlier, sometimes more than a decade earlier, you should be suspicious. That's a red flag. If the reason the government is going to ask you to conclude that President Trump knew anything about this voucher system is because of something that he wrote in a book where he was assisted by ghostwriters decades earlier, there's going to be a problem with the proof. Proof beyond a reasonable doubt does not include a passage in a book from decades earlier, ladies and gentlemen. So you heard also from Ms. Tarasoff about how she decided how to put information in the vouchers. And she told you, remember, this is an email that was sent on Valentine's Day on 2017, where Mr. McConney told Deb, quote, pay this from the trust, post to legal expenses, and put retainer on the months of January and February of 2017. Very clear instructions, and it's exactly what Ms. Tarasoff did. But I just read the whole email. There are 3 separate sentences. Each of these sentences should give you, without a doubt, reasonable doubt. We already talked about the retainer issue. You can see that, you saw this in the records of the voucher, that what Ms. Tarasoff was told to do is exactly what she did. She followed Mr. McConney's instructions. But she didn't follow President Trump's instructions. She didn't follow Alan Weisselberg's instructions. She followed Mr. McConney's instructions. Now she booked it as a legal expense, which, by the way, as both she and Mr. McConney told you, every single invoice that came to the Trump organization, whether President Trump's personal accounts or elsewhere, that came from a lawyer or a law firm, was booked the same way as a legal expense. So, back to the email. There is no other way to categorize an invoice from a lawyer to President Trump than to call it a legal expense. The government has criminalized that, has said that that was a crime, what Ms. Tarasoff did. That's absurd. It's not a crime. This is what Mr. McConney said about that. Payments to the Trump lawyers by the Trump organization are legal expenses. That's why you booked them that way on the general ledger. Yes, that's how they were booked. And you can see that again on the voucher that I'm displaying on the pullout. Same thing from Mr. McConney confirming what I said a moment ago, that there is basically just a drop-down menu. This isn't Ms. Tarasoff creating some long explanation for how somebody should be, how an expense or an invoice should be categorized in the system. It's a drop-down menu, and it's called legal expense. Now, you have heard from Mr. Connie the reason why this was done. Remember, and the transcript is on the screen now, the purpose was basically to make payments to attorneys so that they could be reviewed at the end of the year, right? Correct. And that's exactly what they did. That's not the story. That's not the explanation the government gave you in opening when they said this was some elaborate way to cover up a $130,000 payment. That is not what the evidence showed. So back to the same email. Now we are at the first sentence. Please pay the trust. Now let's first stop for a minute on this. This is a couple of weeks after President Trump had been inaugurated, right? It's February 17th of 2017. He moved to Washington, D.C. And at that time, as you heard, all of President Trump's assets were moved into a trust. The purpose of this was to avoid any conflict of interest. And remember that trust went into effect January 20th, the day that President Trump was sworn into office. And as there was testimony about that from more than one witness. I apologize, that's my neighbor's motorcycle, everyone. This was a very confusing time for the Trump organization. There were adjustments that were being made, not a surprise. And exactly so. Why does that matter? Well, it matters because, as Mr. McConney said, initially they wanted to pay Mr. Cohen out of the trust. There was some flux and chaos at the time because President Trump had just, for the first time in decades, not been the person running the Trump organization. So let's look at the same email a little bit further down. Okay to pay as per agreement with Don and Eric. Now, who are Don and Eric? You all know who they are. They are President Trump's son, Eric Trump and Donald Trump Jr. They are two of three people that were running the company, right? While President Trump was in office. This is one of the charged documents that President Trump is charged with a felony, okay? If there was some sort of conspiratorial agreement, as the people have suggested, because President Trump to Mr. Cohen and Mr. Wesselberg, if there was actually an agreement between the three of them to pay Michael Cohen as a cover-up, this email does not exist. There is no reason to go and get approval from Don and Eric if it's already been decided that we are going to pay Mr. Cohen $35,000 a month. Don't tell anybody, because it's not really for legal expenses. It's actually just a payback from the $130,000 NDA. Then why does this email exist? Then why do Don and Eric have to approve anything? Again, I apologize, that's my neighbor's motorcycle. So you know, and I don't have to answer to why the people notwithstanding this email tell you that there's a conspiracy that exists. But guess who else you did not hear from in this trial? Don or Eric. Is there some allegation that they are a part of this scheme, that they are a part of the conspiracy? Now, there is not even a tiny little bit of evidence that suggests that, ladies and gentlemen. That is reasonable doubt. We have no burden to do anything. The burden is always on the government. They make decisions about who to call at this trial. They called Cohen. They did not call Don and Eric. So remember what Mr. McConney told you after the first couple of payments were made. After the first 3 payments were made from the trust, somebody realized, do you know what? Mr. Cohen is the personal attorney to President Trump. The trust shouldn't be paying that. President Trump should be paying that out of his own personal account. And that's what they did. They recognized that as they settled in, that because it was the personal attorney to the president, that it didn't make sense for the Trump Organization, for the trust to pay it. They made a mistake the first 3 months and they fixed it. And again, that's not evidence of a scheme or intent to defraud. That's just what happens, and it shouldn't surprise you. And so we can talk about the checks as well while we're at it. And I apologize, everybody. Now there are 11 checks, right? Because the first check was for 2 months, was for $70,000. Exhibit 4, which was what you see on the screen. It's a $70,000 check relating to the months of January and February. And the second one, People's Exhibit 7, is a $35,000 check relating to March. You know that both of these checks were approved by Eric and Don Jr., and President Trump had nothing to do with them. There's no evidence that he had anything to do with anything involving either of those checks. They are signed by Eric. They are signed by Eric Trump and Mr. Wesselberg, not by Mr. Trump. But as you know, President Trump signed the remaining checks at the beginning of April of 2017. There is an example on the screen to remind you of what they look like. Now, these checks don't have any of the language you will see from the invoice Mr. Cohen sent. They just say retainer. And as you remember from Mr. McConney and Ms. Tarasoff, that was just a generated word from what was put into the voucher. There's nothing sinister or criminal about that word. It's just generated when a check is printed after that information is put in the voucher, not by President Trump, not by Alan Wesselberg, but Deb Tarasoff. So you shouldn't think that the word retainer specifies or differentiates between any reason for the payment. It's just a single word. It's just a word that, again, was generated by the MDS system. Now, there was a lot of evidence, and in openings, there was a lot of talk about how President Trump signed all of these checks beginning in April of 2017. Now, as you have heard from 2 witnesses, President Trump was very busy. He was running the country. It shouldn't be a surprise about that. And one of the witnesses, Miss Westerhout, told you that she remembers is that sometimes President Trump would look at the checks and the invoices, sometimes he would not. And again, that isn't surprising. She testified that sometimes there were a lot of checks, a half inch of personal checks, because remember, nobody had the signatory authority on President Trump's personal account except for President Trump. So when there were checks that had to be signed, only he could do it. So you can't convict President Trump because sometimes without anything specific at all to a particular charge in this case, President Trump looked at the invoices that somehow he had full knowledge of what was happening. That is a stretch. That is a stretch, and that is a reasonable doubt, ladies and gentlemen. Same thing with respect to the Federal Express. You heard about the Federal Express process that was used. Nothing sinister. It was used because it was a quicker way to get information to President Trump. Again, not surprising when he was in the White House. Now, it wasn't even just President Trump that received information that way. Do you remember? You also heard the First Lady got information from Federal Express. Ivanka Trump, the president's daughter, got it in the same way. So the fact that the checks and the personal information was FedExed from Trump Tower to Keith Schiller and then given to President Trump, there's nothing sinister about that. It's common sense when you hear the explanation of why, which is you heard from the witnesses. Now we've got court reporters switching, everyone. That's the notation there. And then back to Todd Blanche's summation. I will take a moment for a tea break. Now, as I just said, it matters where President Trump was during this time. He was constantly moving. He was very busy. He was frequently multitasking. People were constantly interrupting him. He was president of the United States. So the idea, the leap that the government wants you to take, that he looked at the checks, looked at the invoices, and was part of the scheme, and remember what the scheme is, to book a legal expense as a legal expense, that's the scheme. That he somehow was in on that is absurd. And again, this is where Miss Westerhout told you that sometimes he would sign the checks even when he was meeting with people, while he was on the phone, and even without reviewing them. Again, nothing surprising there, but it's worth remembering. Now we're going to talk for just a few minutes now about Mr. Cohen. How is the government going to ask you to convict President Trump based on the words of Michael Cohen? Even without Mr. Cohen, what we just went through, the government can't get by with that. The invoices were not generated by anyone at the Trump Organization. They were generated by Michael Cohen. They were sent to the Trump Organization so he could get paid. The fact that the invoices refer to a verbal retainer agreement when you know that there was an attorney-client relationship between President Trump and Michael Cohen in 2017, the fact that the invoices talk about services rendered by Michael Cohen, and you know that he was rendering services during that time in 2017, all that ends the case not guilty. But there is a lot more. What the people have done, what the government did for the past 5 weeks, at the end of the day, is ask you to believe the man who testified 2 weeks ago, Michael Cohen. Michael Cohen asked you to ignore the documents, ignore what the email says about sending him a retainer agreement sent by Mr. Weisselberg, asked you to believe he was just going to work for free. You saw him on the stand for 3 days, more than 3 days. Do you believe that for a second, that after getting stiffed on his bonus in 2016 when he thought he had worked so hard, he got stiffed when he didn't get paid back the $20,000 he was owed. Do you think that Mr. Cohen thought, I want to work for free? Is that what that man who testified, or was that a lie? Now, when we get to Mr. Cohen's testimony about the issue, we're talking about the retainer agreement, about what he was going to do with it in 2017. Just remember something. It's not corroborated by anything. There's not a shred of evidence. What Mr. Cohen told us is that first he talked to Mr. Weisselberg privately, and then he walked down to the hall, unscheduled, unannounced, walked into the office of President-elect of the United States, who was preparing to be inaugurated just a few days later. And what he wants you to believe, what Mr. Cohen wants you to believe, that he just sat back, Mr. Cohen didn't really participate in the conversation, and you can see what he said about it on the screen. At some point during this conversation, apparently between the president and Alan Weselberg, he turned around and said to me, well, we're talking about this, and what we're going to do is we're going to pay you over 12 months. Mr. Cohen didn't pretend to be part of that conversation. He said all President Trump said to him is, it's going to be one heck of a ride in D.C. That's the evidence. That's the evidence and corroboration the government gave you about President Trump's knowledge of this scheme. Now, this is the same time period, by the way, that President Trump decided to make Mr. Cohen his personal attorney. Mr. Cohen told you that. It was around that exact time. So Mr. Cohen has two different meetings with President Trump. One, when he's told you he is going to be his personal attorney. And two, when he and Mr. Weselberg go in and let the president know about this scheme. He wants you to believe that's what gives the president full knowledge. That's what gives President Trump knowledge of what happens. That's a ridiculous story, and I want to tell you why. I mentioned it earlier. But the idea that President Trump would agree to pay Michael Cohen $420,000, even though he only owed him $130,000, is absurd. Cohen even told you that he saw Alan Weselberg hand that piece of paper, which we're going to talk about in a minute, to President Trump for President Trump to look at. So he wants you to believe that President Trump saw this piece of paper where there's $130,000, $50,000 for Redfinch, which you know from testimony, President Trump said, I'm not paying that. But out of the blue, he decides, you know what, not only am I going to pay it, let's double it. Oh, you didn't like your bonus? You didn't think 50 was enough? Let's throw in another 60. That's what Mr. Cohen wants you to believe happened in that meeting when Mr. Weselberg walked in with that piece of paper and supposedly showed it to President Trump. That is absurd. All the other evidence, you heard about how carefully President Trump watches his finances. The first job Michael Cohen got at the Trump Organization, remember, was to make sure every bill that's owed to not have to pay as little as possible. Now, by the way, his version of the events with the campaign are belied by other evidence. He told you he deserved the extra bonus than the normal bonus he normally gets because of all the work on the campaign. What did Ms. Hicks tell you about Mr. Cohen's role? He did things that frustrated the campaign staff, that were frustrating, and at times he went rogue. That's not things justifying a larger bonus. Now, this is the document that we've seen a lot, People's Exhibit 35. This is the document Mr. Cohen tells you he discussed with Mr. Weselberg right before they walked into President Trump's office. Well, the point of this document is it contains lies. Again, you have to accept, if you accept Mr. Cohen's version of what happened, that they were all in this together, that Mr. Weselberg, Mr. Cohen, President Trump were all in this together, but the document that the people offer to prove it is full of lies. The Redfinch, we've already been through a couple of times, is absolutely a lie. The fact that they're going to double it up, gross it up, is a lie. And let's talk about that for a minute. Now, here's what Mr. Cohen told you about the grossed up concept. He told you that he had no idea and that he didn't even care. He said, what, if any, understanding do you have about why he grossed up that reimbursement up to $360? I don't know, and to be honest, I didn't really even think about it. I just wanted to get my money back. What evidence do you have? What evidence do you have that this is a gross up, that this gross up is anything to do with taxes? That's it. That's your proof. Supposedly, Weselberg said something about grossing it up to Mr. Cohen. Mr. Cohen says, I don't know. Is there any other proof of that? Any other evidence? No, there's none. Mr. McConney said something very similar when asked what Mr. Wesselberg maybe meant by gross it up. Nobody would know. Nobody would know. So the witnesses that testified in this courtroom, one says, I didn't know and I didn't care. And the other says, nobody would know. And based on that, I suggest the government's going to suggest to you that there may have been some sort of tax scheme involved here as well. That's it. That's the proof. You saw no evidence of a tax scheme by anybody for this $420,000. Not the Trump Organization, not the personal expenses for President Trump, not even Mr. Cohen. Now, there's also notes, as you remember, from Mr. McConney, where he also took notes from a separate meeting that he had had with Mr. Wesselberg. Now, here's something else that's very important about these notes. Remember when Mr. Cohen told you that he had visited the White House in February? Remember this? We put a photo up of him, and we saw his calendar entry that he was going to the White House. So this meeting was early February, okay? He talked about it. It was a big deal. Now, what did he tell you about that? He told you he was going to the Oval Office for the first time in his life, meeting his boss, the man he worked for 9.5 years, achieved this amazing thing of becoming president of the United States, but they had a conversation about checks, about the money. That's what he wants you to believe. Oh, yes, we confirmed it. President Trump said, do you need money? Do you want me to write you a check? And I said, no. That's what he wants you to believe. But hold on a second. Just 6 days later, on February 14th of 2017, Mr. Cohen had visited the White House. On February 8th, Mr. Cohen sends an email back to Mr. McConney asking, hey, how much does the monthly retainer run again? What am I supposed to do? This is after Mr. McConney emailed him and said, hey, send us an invoice if you want to get paid, Jeff. Please remind me of the monthly amount. So Mr. Cohen wants you to believe February 8th he was in the Oval Office for the first time after Mr. Trump became president of the United States. They have a confirmatory agreement about the scheme and why you're here, but just 6 days later, Cohen doesn't even know how much it's supposed to be. So the last thing I want to say about the notes that we were looking at earlier about Mr. Wesselberg is the notes that you now see next to the notes, which are the notes that Mr. McConney told you he took after separate conversation with Mr. Wesselberg. First of all, Mr. McConney's notes don't reflect $180,000. They don't say what it's for. It just has it written. It says ×2. It also suggests that the money is going to come out of President Trump's personal account, which, as you recall, for the first 3 months, it didn't. There was confusion. So the point is, if you accept the government's position that there was this agreed upon scheme in January, why would Wesselberg say to Mr. McConney things that end up not happening? Why was it the Trump Organization, the Trump Trust documents paid the first 3 months if there was this agreement reached against President Trump, Michael Cohen, and Alan Wesselberg? Now also, you have these, right? They're in evidence. Why are they in evidence? If this is some document, some evidence of a crime, how come, as you heard from Mr. McConney, he took both of these documents and he put them in the record, where he keeps all of the records for the payroll department in his office? He didn't get rid of them. He didn't try to discard them. This is a case about false filings, about false business records. And yet, the supposed evidence of the false filings were in the records of President Trump's personal account in the payroll cabinet of Mr. McConney's office. Does that make sense? So for all of those reasons, you don't have to go further. President Trump is not guilty. But I expect that you're going to hear from Judge Merchan that there's something else that has to be proven beyond a reasonable doubt. The government has to prove that to you that President Trump caused these entries, even if false, with the intent to defraud. That means like a conscious objective, a purpose to defraud. There is no evidence of that, ladies and gentlemen. First of all, the records aren't false. But even if they were, where is the part of the intent to defraud by President Trump? And how do you know there's no intent to defraud? Well, you saw the evidence that the Trump Organization reported this. There's a 1099 that reflects the payments from the trust and also from President Trump's personal account to Michael Cohen. Now, there's nothing false or misleading about the 1099s. It's like any 1099 you give somebody who's working for you. So if there was some deep-rooted intent to defraud, why do you think it was reported to the IRS as exactly what it was, to Michael Cohen as President Trump's personal attorney? Now, Mr. McConney is the only witness who testified about the 1099s at this trial, and he told you that there is no way on the 1099 form, as you can see there, to differentiate between whether it's a legal service or a various expense. You just mark it and you send it to the person who works for you. In this case, Michael Cohen, and it's his responsibility to deal with it with the IRS. There's nothing criminal about that at all. It's just the way it's supposed to be done. So that's one reason why there's no intent to defraud. But also, you can look, by the way, these forms are in evidence, so you don't have to take my word for it. But they're exactly accurate. Mr. Cohen at the time was a non-employee at the Trump Organization. He was a personal attorney to President Trump, an outside attorney, and the payments were compensation to him, period. Nothing false. Now we offer these documents through Mr. McConney, not the government. Objection! But they're important, sustained. They're important. It shows that the Trump Organization disclosed these payments. They disclosed these payments to the IRS, both from the trust and from President Trump's personal account. How else do you know there's no intent to defraud? Well, you saw President Trump send out a tweet in 2018 saying exactly what he did. If there was an intent to defraud, why would he do that? Now, finally, you saw that there was a document submitted after President Trump was in office to the Office of the Government Ethics, where, again, the payment was disclosed to the federal government. He signed the form, and an agency official concluded he was in compliance with the applicable laws and regulations. You can see the language that's described there. It's a little small. In the interest of transparency, while not required to do so, the payments to Mr. Cohen were disclosed. So how can it be there's any intent to defraud by President Trump when he discloses it to the IRS? He tweets about it and he submits it to his Office of Government Ethics forms. So I'm going to talk a little bit now about what I expect the government will talk about, which is a conspiracy to influence the 2016 election. I don't even think you have to get to this, because with what we just talked about, with the forms that were filed, the way that they were booked on President Trump's personal records, there's no crime, period. But even if you get to ask yourself about any conspiracy to influence the 2016 election, I expect that you will find President Trump is not guilty. Now, the government's theory is that in 2017, so after the election is November of 2016, President Trump caused false filings, which we just talked about, to be made on books of his personal records to promote a candidacy in an election that he had already won. The charges relate to documents in 2017, and the government wants you to believe that President Trump did these things with his records to conceal efforts to promote his successful candidacy in 2016, the year before. By the way, even if you find that's true, that's still not enough. It doesn't matter, as I said to you in the opening statement, it doesn't matter if there was a conspiracy to try to win an election. Every campaign in this country is a conspiracy from another candidate, a group of people who are working together to help somebody win. In order for you to find that there was an intent to conceal an election-related crime, you have to find that this effort was done by unlawful means. I expect the government will talk about 3 separate unlawful means, okay? 1, federal campaign finance violations. 2, tax violations. And then the third is his other books and records violations. But I'm going to spend a few minutes talking about all 3 of those. None of them make any sense. let's talk for a minute about the August 2015 meeting that you heard a lot about from Mr. Pecker and you heard about from Mr. Cohen. That's supposedly where this conspiracy starts. There's an August 2015 meeting at Trump Tower. David Pecker, President Trump, Michael Cohen is there, and at the time, supposedly, Hope Hicks was in and out. Well, what you heard is that Mr. Pecker agreed that he would be the eyes and ears for the campaign, that AMI would do what they could to publish flattering stories about Mr. Trump, and that AMI would attack President Trump's opponents. But this is from Mr. Pecker's testimony, ladies and gentlemen. This is the same thing AMI had been doing for decades. They had been doing it for President Trump since the 90s. Mr. Pecker told you that AMI purchases stories all the time. They purchased stories about Tiger Woods, Mark Wahlberg, and other people. And this was good business for them. Mr. Pecker told you this allowed him to have a mutually beneficial relationship with celebrities. He talked about Ron Perlman, Rahm Emanuel. He also told you it wasn't unique to President Trump, that in fact many politicians work with the media to try to promote their image. No crime. He said actually it was standard operating procedure to do so. I'm going to pause just for a moment, everybody. Can I ask you to hit the like button? And the reason why is because the hearts help me keep my page in view so that I know I'm in the right screen. My screen has been bumped. Oh my gosh, thank you so much. Let me just line my page up. Thank you so much, everybody. I appreciate it. Okay, there we go. Okay, thank you. Thank you so much, everybody. And not just President Trump's campaign, other presidential candidates did it long before 2016. It wasn't just Mr. Pecker. Hope Hicks told you exactly the same thing. It's not uncommon for campaigns to work with media to run campaign themes. It's a regular practice. Again, this isn't surprising. Campaigns want to amplify the good things about their candidate and expose the bad things about their opponents. Again, this is a campaign. This is an election. This is not a crime. Even Mr. Cohen told you exactly the same thing. He spent decades working the media to help him or to help President Trump push forward a story or a version of events or to suppress something that's being told. Again, nothing criminal about it. It's done all the time. Remember, Mr. Pecker gave you that story, gave you an example of something that happened with him and Arnold Schwarzenegger. Do you remember that? It was a while ago. He told you that he had helped Mr. Schwarzenegger suppress stories from more than 30 women, including a book that had been written. Mr. Pecker told you that he had spent hundreds of thousands of dollars on this. Indeed, it even led to an investigation by the California state authorities and changed AMI. But as to this courtroom, there were no criminal charges brought as a result of that. Now remember another story that Mr. Pecker told you about another person running for elected office named Rahm Emanuel. It's Ari Emanuel's brother, who is a big power broker apparently. What Mr. Pecker told you that in 2010-2011, he helped suppress a story about an affair that Mr. Emanuel had to help Mr. Emanuel run for office in Illinois. There were no issues with the Federal Election Commission. There were no claims that any laws were broken. And by the way, that's exactly why Mr. Pecker believed that what he was doing when he met with President Trump and Mr. Cohen in 2015 was perfectly legal. Objection, sustained. Sorry, sustained. So you have decades of AMI doing exactly the same thing with respect to stories, working with celebrities and politicians to promote campaigns and suppress negative stories. There's zero criminal intent in that 2015 meeting. Indeed, Mr. Pecker told you that it was a really good business to work with President Trump. He explained to you that the positive stories actually started when President Trump started running The Apprentice in the early 2000s. As far back as 1988, Mr. Pecker told you that he had helped suppress a story for Mr. Trump in 1988. That's 17 years ahead of the August 2015 meeting, and again in 2007. So 8 years before the August 2015 meeting, Mr. Pecker told you that he started to work with Mr. Cohen to help President Trump. So this had been going on for decades. It had been going on for 8 years with Mr. Cohen and Mr. Pecker. And they were friends. No dispute about that. Mr. Pecker said that a couple of times. But this was also not just about friendship. This was good business for AMI. They made a lot of money based on the relationship, not surprising. And then in 2015, when they had that meeting, oh my gosh, John, thank you. There's no doubt that one of the reasons why Mr. Pecker agreed to it was that it was good for business. He told you that President Trump was absolutely the top celebrity that helped sell magazines. And of course, Pecker wanted to make money. He ran the company. And so it's not just, by the way, it's not just Pecker being greedy and wanting money for himself. He had shareholders. It was his fiduciary duty, oh, thanks, John, to make money for his shareholders by promoting President Trump. Again, not a conspiracy, no criminal intent. It's AMI's doing what they do and what they have done for decades. Now, so there's nothing wrong, and I said this in our opening statement, with a politician like President Trump trying to get a positive stories and ones. Nothing criminal about it. But let's be clear about something else. The idea, even if there was something wrong with it, the idea that sophisticated people like President Trump and David Pecker believed that positive stories in the National Enquirer could influence the 2016 election is preposterous. Let's take a moment. But let's be clear about something else. The idea, even if there was something wrong with it, the idea that sophisticated people like President Trump and David Pecker believed that positive stories in the National Enquirer could influence the 2016 election is preposterous. Ooh, goodness. Mr. Pecker told you that the National Enquirer's circulation at that time period in 2016 was around 350,000. The New York Times' circulation was multiples of that number. Millions and millions of people voted in the 2016 election. So the idea that they really thought this meeting at Trump Tower in 2015 would ultimately influence the election makes no sense. And here, by the way, here's why that matters. The government wants you to believe that in August of 2015, Mr. Pecker, President Trump, and Michael Cohen all got together in President Trump's office and said, okay, we're going to commit a crime. Let's enter into a conspiracy to influence the election in 2016. And that's what they came up with. Now, what were they going to do? You saw a bunch of the articles in this trial that have also been published by the National Enquirer about negative stories about the folks running against President Trump and positive stories about President Trump. But what did they actually discuss at the meeting? What did Mr. Pecker tell you that they actually discussed? There was no in-depth discussion, and Mr. Cohen tried to tell you that there was. There was no in-depth discussion about how they... sorry everybody, would get together and publish really negative stories or really positive stories. It was just a general discussion that Mr. Pecker told you about in 2015 of an effort to try and help President Trump. So remember also that a lot of the stories that the National Enquirer ran were just recycled. Remember, many of the stories had already been published by other organizations, all the stories that you see on the screen. Now, the idea that the National Enquirer could corruptly, criminally influence, thank you so much, an election by republishing stories that had already been out there in other forums should hopefully make you shake your head. It makes no sense. Now remember what the government told you about this August 2015 meeting and what happened thereafter. Now, what they told you, remember the words catch and unalive. They told you, I'm going to talk to you about the three Ketchen unalives. They put it in front of you in this trial. Remember that they told you this was the heart of the agreement, the Ketchen unalive scheme, but they didn't even discuss Ketchen unalive at the August 2015 meeting. Mr. Pecker told you that. Mr. Cohen didn't dispute that. There were no financial arrangements discussed at that meeting. Oh, thanks, Kristen. Think about that. The government wants you to believe that the three stories we're going to talk about, Miss McDougal, Miss Daniels, and Dino Sujadin, were the essence of the Ketchen unalive scheme between Mr. Cohen, AMI, and Mr. Trump. And it wasn't even discussed at the time the conspiracy was formed. No financial discussion, no discussion about the Ketchen unalive. Think about that. So Mr. Pecker told you about the first time that he heard Ketchen unalive, and he said it was from the investigation. And then on redirect, he was asked whether he actually read it in an article. And he said yes, oh my gosh, John. He read it in an article earlier, but make no mistake about it, there was no Ketchen unalive discussed at this August 2015 meeting when the supposed conspiracy was born. So let's talk for a few minutes about the Ketchen unalive scheme. Keep in mind, there's nothing unusual. Mr. Pecker told you this about catching and unaliving. What did Mr. Pecker tell you? He said they only published about half of the stories that they bought. Half of the stories. So, and by the way, Mr. Pecker knows a lot, right? He took the stand a month ago. I know you've seen a lot of testimony since then, but he's been in this industry for decades. And so when he talks about the work that he's done over the years and the way that he ran AMI, he was speaking from experience. So when he tells you that he never heard Ketchen unalive until the investigation or until a news article about it sometime relatively recently, that's meaningful. When he tells you that half of the stories that the National Enquirer buys, they don't publish, that's meaningful. That matters. So let's talk about the three Ketchen unalives. The first one, Dino Sujadin, a supposed love child, completely 100% false. Everybody told you that, literally a made-up story designed to harm President Trump. Not true, and also harm his employees and folks that work for him. Make sure again, apologize everyone. This bubbled up a few months after the August 2015 meeting, right? We're still in 2015. And what did Mr. Pecker tell you about that? When he learned about this, he said he was always going to do what was best for AMI, and that if this story was true, he was publishing it. He said he would have the biggest story AMI had ever had. He estimated he could have sold 10 million National Enquirers, and that he had a fiduciary obligation to his shareholders to sell the story. That doesn't sound like a Ketchen unalive at all. Now, Pecker told you he never discussed the story directly with President Trump. He just talked to Mr. Cohen about it, and that makes sense. Remember, he told you that he was trying to figure out what was true. If it was true, he was going to publish it. So he wasn't talking to President Trump about it. This isn't a Ketchen unalive. This is an opportunity. The biggest story we ever had, 10 million copies. It's worth too much to catch and unalive. Full stop. You can see when he talked about it, Mr. Pecker was in fact truthful about that. On redirect, he said, I wouldn't have published it until after the election. But that doesn't make any sense. He was trying to verify this story in 2015, months and months before the election in 2016. It would have been the biggest story the National Enquirer ever had. Think about that. The government wants you to believe that in August of 2015, there was this super conspiratorial criminal meeting where Mr. Pecker is going to criminally help President Trump win the election. And the first opportunity he gets to really work this conspiracy, really help President Trump, he says, no, I'm publishing this. What kind of conspiracy is that? The first opportunity you have to really do your thing with your co-conspirators and suppress a story and Ketchen unalive a story? No, this is the biggest story ever, and I'm going to figure out if it's true, and if it's true, I'm going to publish it. That's the evidence. That's what you heard. The reason they didn't publish this story, by the way, was it a catch and unalive? No, it's because it was false. The story was not true. That's why it was never published. So if you look at the original agreement between AMI and Mr. Sudjadin dated November 15th of 2015, totally standard document as you heard, nothing unusual. They were going to pay $30,000 if they published the story. Nothing unusual. That's the way the National Enquirer normally did it, and a 90-day period of exclusivity. Again, Mr. Pecker told you that was all standard, so AMI is just doing what it always does. Then what happens? A little bit later in December of that same year, they amended the agreement, and under the amendment, AMI owed $30,000 to Mr. Sudjadin, and they paid it, and it lasted forever. This agreement never expired, and Mr. Sudjadin could never talk about it or he would owe a lot of money. And what did Mr. Pecker tell you about why they did this, why they switched and actually paid him the money without actually writing a story? He told you that Mr. Sudjadin was threatening to go someplace else, and they had to see if the story was true. So if they didn't agree to pay him $30,000, there was a risk he would go somewhere else. And again, if it was true, that was getting published. That's why he decided to pay Mr. Sudjadin, correct? Yes. Mr. Pecker told you the reason why he did that is because it's still possible in his mind that that story was true. That is correct. That is not a catch and unalive. It's just not. Mr. Cohen, when he talked about this, by the way, he lied to you again. He lied to you about the amendment. He says he told President Trump about the details regarding Mr. Sudjadin. He said he did that because he wanted to take credit. He wanted to take credit with President Trump. But you can see that he really, when we cross-examined him on this issue, he really didn't even fight. He admittedly didn't tell President Trump all the details. He never told President Trump details like this. Objection, overruled. Again, on direct, he says one thing. On cross, he says another. He is not telling the truth. He's lying. So Mr. Cohen, by the way, used credit constantly, right? He constantly said to you he wanted credit. He wanted credit from President Trump. He did something because he wanted credit. He kept President Trump updated because he wanted to take credit for himself. He told you that repeatedly on direct and also on cross. Why do you think he did that? That's the same phrase that Hope Hicks used in describing Mr. Cohen. She described Mr. Cohen as being somebody who always wanted credit. Mr. Cohen admitted to you that he was following this trial before he testified. Just think about that for a minute. He came in here and testified 2 weeks ago, but admitted because he had to that he had been following this trial earlier in this trial. Why do you think suddenly credit was part of his story? Is that something that can be trusted as the truth? Absolutely not. I want to talk now about Miss McDougal. That's the second catch and kill, right? Now, Miss McDougal didn't testify at this trial, but you heard about her affair. Again, just like Mr. Sudjadin, there was never any money paid by Michael Cohen or President Trump for AMI for anything involving Miss McDougal's story. But what is clear from what you've heard about Miss McDougal, this was not a catch and unalive either. Everybody said the same thing. Karen McDougal did not want her story published. Catch and unalive. We're going to catch a story from being published and keep it from being published, and then we're going to unalive it. Miss McDougal didn't want her story published. She wanted to kickstart her career. She wanted to be on the covers of magazines. She wanted to write articles. She didn't want to publish the story. She wanted to write articles with AMI. And again, she did that. Again, how is that a catch and unalive? It's not. So, and her attorney said the same thing. It wasn't one side. She told Mr. Davidson she did not want to publish her article. You can see it on the screen. Miss McDougal did not want to publish an article about the claims that have been discussed here, right? True. You can see one of her friends forced her hands, and that friend publicized Miss McDougal's allegations, so she was trying to take advantage of the situation. To be clear, it was not Miss McDougal's intention to publish her story. And again, the reason why this matters, the reason why the details of what happened back in 2016 matter to you and should matter to you is that there was never any risk that her allegation could influence the election because she didn't want her allegations published. Remember why you're thinking about these incidents. It's because the government has alleged a conspiracy to influence the election. And second of three, didn't want to influence the election at all. She didn't want her story published. So she was paid $150,000. No questions about that. You saw the documents and you heard the testimony. But remember why. Miss McDougal had an entourage around her. Remember, Davidson took 45% of the $150,000. You also heard about her bodyguard. That was Johnny Crawford, and he was a police officer who was providing security. All of them would have been compensated, and you also heard about her manager, Gene Rodriguez, who was also compensated. All these people around Miss McDougal wanted to make money, of course. So whatever she ended up with from the $150,000 was not much, and again, did not seem to bother her because that was not her motive. She wanted to be on the cover of magazines. She wanted to write articles. She was not trying to get her story published and then have it caught and unalived. So let's talk about what happened again, the legality of the situation, okay? So you have the government's argument that what happened here was somehow important. Okay, there was something wrong about to happen. That's not what Mr. Pecker talked about and not what he told you. Remember, he told you that he consulted with an attorney. Objection sustained. Let's go back to what he said. He said he submitted a declaration under objection overruled, under penalty of perjury. And this is a declaration of legal advice that you had received relating to the agreement with Karen McDougal, correct? Yes. And it said that the agreement was lawful. So he told you that he didn't keep anything from his lawyers when he talked about it. He told you that on cross. And you can see that here. And also, you know that Mr. Pecker has an agreement with the district attorney, with the prosecutors in this case, that provided him with immunity. And you can see that it's in evidence. You see the paragraph that is applicable to what we're talking about now, that if the district attorney, if the prosecutor determined Mr. Pecker provided any false, incomplete, or misleading testimony, that the agreement is then breached and that he could be subject to prosecution. But you know, Mr. Pecker is not being prosecuted for anything. You know that. And so we have another court reporter switch, everyone. So I will take this time to go ahead and stop the reading for this particular live. I have been going here for an hour. So I will go ahead and turn on so we can do a brief Q&A and kind of talk about things a little bit at this point. So let me see here. Get my settings set. Here we go. And there we go. The settings should be just, nope. Hold on, everyone. Just give me a minute. Oh my goodness. There we go. Now we got them. Hello, everybody. Hello, welcome. Welcome in. Thank you for joining us today. Let me see if I can get some visual aids going here. Here we go, Mr. Cohen. We'll put him up. Hello, everybody. Hello and welcome. Yes, hello. We are. Hello, Kristen. Oh, worst closing argument ever. Well, you know, it's not done, but oh my goodness gracious. Yes. I think, you know, oh my goodness. Oh, the cowboy hat. Oh my gosh. You know, it doesn't seem particularly organized at this point, but again, it's not over yet. So we will see. We'll see how things go. Yes, good morning. Hello, Erica. Hello. Subscriber. Oh, thank you so much, Shell. I appreciate that. Look, no, spicy. Oh, I'm trying to not be too spicy, although the last few days, I think I've gotten a little bit more spicy over the last 2 days, everybody. Is he moving too quickly? Doughboy, that's a great observation. I think he is. I think he is moving too quickly. But then I think the reason why is because he doesn't have much. He doesn't have much to really rely on to kind of really go into the details. So he can't give too much detail because there aren't any. And so he's got to kind of skip around to draw it out a bit. A lot of things that reinforce the prosecution's case, he did, Daisy. And a lot of times you want to do that on closing. You want to go in and grab at the weak spots and kind of take care of them early. But that can always backfire by actually giving more information if the prosecution would not have used that. Now, I've not read them yet. I've not read theirs yet, but yeah, definitely. Yeah, he doesn't have, there's just really isn't, there really isn't much. Make me watch my husband play golf, Bearball. Oh, we are most welcome, Maura. Oh my goodness gracious. Could have called his witness to interview Zartman. Yeah, I agree. So much back and forth with this information. Yeah, and it really is, he's closing statements, or why they call it a summation. They are not evidence. It is a persuasive argument. And so you're trying to persuade the jury. But you're also walking them back through the evidence. And, there just wasn't much evidence for the defense to stand on that was helpful for them. So I think I think that that's one of the hardest parts for them. If you don't have much to rely on, then it just turns into, smoke and mirrors. It turns into kind of a show. Why didn't Karen testify? I don't know. I think that's a great question. But, I think the prosecution wanted to keep it clean, keep it, lean and clean. And so they didn't want to kind of clutter extra things up. And the defense, I don't know what they were doing with their witnesses. I just don't even know at this point. I'm not sure. Boop the screens. Kristen. Oh, stop. No, don't worry about it. I just noticed. I was like, wait a minute, where's the heart? I need the heart as the guideline on the right-hand side. Oh, that's so funny. Heard the other girl had a thing for Trump. Yeah, was probably heartbroken. I think that would be fair to say from the reporting I've heard. Again, I have not heard directly from her, so I do not know. But I would say that sounds accurate. And so I think what he was trying to say is like, how could this be a conspiracy when she didn't even want her story? So it wouldn't have even mattered. And the second one, Mr. Sujadin, it wasn't even true. So that's two of the three. But then again, it's like, well, two of the three might be down, but you still have the third one, and that's Stormy. And that's pretty good story. More opportunity. Yes. Yeah. The more witnesses, the more opportunity to sow doubt. Absolutely. Mouse first. Now that I'm not a medical doctor. I do have a doctorate, but it's not in medicine. So I don't know. Why spending so much time on the retainer agreement? Right. So I think what my best guess, and, again, I'll be coming back for the rest of summations here. But I think my best guess was they were trying to figure out a way to to back up the term legal expenses. So, this whole thing came about because we had legal expenses was the false information written on the documents. And so they're saying the legal expenses covered the retainer. But then again, that was also false information. So that argument wasn't working for them. But I think that was just another one of the techniques that they were trying. They can really object. They can. It's unusual, Nancy. We've seen it a lot in this case, in opening and in closing. It is unusual. It's unusual to do that. And I think for the state at this point, because, the defense kind of pulled some tricks. And honestly, we've not gotten to it yet. We will. But Mr. Blanche really pulled a really dirty trick during closing. So, I'm not surprised. I think you can really get a feel for the attorneys that you're working with. And if they're going to be playing kind of dirty tricks, you got to do what you got to do to keep your record going forward. So I think there had to be some objections in there. Yeah, it is rare. It is rare, Erica. It's rare to have objections in openings and closings. It's not that it doesn't ever happen. It's just it is rare. You don't usually see that. It just, yeah. It can happen. It can absolutely happen. And you certainly don't want to hold your objections in. If you have an objection during closing arguments and you're like, wow, I should have objected to that. And closing arguments over and you're like, oh, I object to that. And the judge will be like, well, closing arguments are over. Your objection is moot now. You don't want to have that happen. So it's better to be like interrupt and have that weird moment where you're like objection during a closing than to actually miss a good opportunity if there's a proper legal expenses. That's right. The coins, right. Yeah, the toner. I'm sure there was a lot of toner involved. Oh, that's so funny. Oh my goodness gracious. Will Blanche pay for that down the road? Good question. Good question. And I'm not sure. I think I would hope so. I would hope somebody would be calling him out. I'm starting to, have a little bit more faith in these attorneys being called out now that I'm seeing a lot of them losing their licenses. So hopefully something will happen. Conspiracy normal during a presidential campaign. Oh, I know. That's another thing too, isn't it? He was trying to say, well, look, that's just what happens during a campaign. Everybody conspires to win. And, he knows this because he has worked in criminal law. Conspiracy is a crime. There's certain elements required. And, the crime is that you're intending to do a crime. So with a campaign, you're not intending to crime, you're intending to win a campaign. So, I mean, that's just not the same thing legally, and he knows that. But I think he was trying to kind of twist that language up to maybe confuse the jury a little bit on it. SCOTUS will do. SCOTUS doesn't have any jurisdiction. There's just no jurisdiction. That's the thing, is you can you're like, oh, SCOTUS, yay, SCOTUS. It's Trump's SCOTUS, but still, you got to have jurisdiction. I mean, SCOTUS can't just be like, hey, let's just go ahead and decide on this case, which is so interesting, everyone, because if you remember in the very beginning of all of these cases, when the Florida case came out, everybody was like, ooh, SCOTUS is going to come in and take care of that. And it's like, well, why would they? They have to have a question in front of them. Now, the Florida case is federal, but when it comes to New York and Georgia, it's like, those are state cases, man. That federalism is, pesky. But you've got to have some kind of question in order to get in front of them. They can't just go around and pluck cases, and thank goodness. Did you see any issues that might give appeals court overturn on any rulings? When I'm looking through the case, I'm not really keeping appellate questions too close in mind. Reading Judge Merchan's orders, the one thing I will say is on his orders, they were very well supported by precedent. So with his rulings and with the orders that he made, he had backup for it. He was citing case law, he was citing the precedent there. So that's always good. Because, then the appellate court's like, well, are you going to overturn your precedent here? And he's supporting his decision. He's saying, this is why I'm deciding this. When it comes to objections and sustaining, when you're in the heat of the moment in trial, I suppose things could get kind of uncomfortable. But the thing about the sustaining an objection during a trial, that's muscle memory. And that has to do with how many cases you've tried. And Judge Merchan has been a judge for so long that when he's overruling and sustaining, that's just muscle memory. He knows the law. He knows the rule. He knows what's appealable. So his decisions are going to be made off of, 20 years experience. So unlike if we were, with Judge Cannon, where she doesn't have the same amount, if she's doing an overrule or a sustain, it could be appealable. But Judge Merchan's been doing this for so many years, and he probably has had some sustains and overrules that have been appealed, and so he knows better about how to do it. So I would say, based off of his experience, in courtroom objections, I don't see are going to be particularly a problem with a judge that's this seasoned. Again, his orders were just very clear cut. So I don't really see anything that jumps out at me, but it doesn't mean that there isn't. It doesn't mean that there's not, the appeals process is part of your constitutional right. So, everybody that want, that should, that can, that where it's appropriate, where it's not frivolous, go for it. Go through that appellate process. If it's frivolous and a bunch of bologna sandwiches, like, that just means that your attorney is a big jerk for filing all of that crap. But the court can do to intervene on those. Great question, Katrina. And, those would have to be criminal charges. If you have harassment or intimidation, those kinds of things, those are just separate criminal charges. So it's not that the court can really come in and do anything. It's that law enforcement or that branch of government is going to have to come in and protect them. It'll be up to what New York law has set in place to protect their jurors. Allowed to contribute to political campaigns. Sure, why not? Why not? It depends on your jurisdiction. It absolutely depends on your jurisdiction. If you're in a jurisdiction where your judges run for election and they have to declare if they're a Democrat or a Republican or an independent, why wouldn't they contribute to other campaigns? That's not illegal. If you're in a place where they don't have to campaign like that, maybe that could be a question. But it's whatever your rules are in your area, and every place is different. So if your rules say you can do it, if your statute says it's fine, then fine. I'm not a fan. I am not a fan of judges having to run. I'm not a big fan of that. I don't think that is good, because I don't think they should be biased one way or the other. But on the other hand, I'm also not a big fan of lifetime appointments. So it's hard. You got to find something in the middle. Which I think is like, there's a process called the Missouri process where you get appointed and then you get voted to be retained. So it's kind of like a hybrid of that. And that I think is something better. But, what are you supposed to do? You either run for office or you're there for life. Like, which one's worse? It's a tough call. I'm not really sure which way you want to go. So every state has made their own decisions, other than what's listed in the Constitution for our federal judges. Really? Now, Murray, I didn't know that. Now, I've got a note to myself. I have several notes to myself on what happens with Secret Service. So I am looking into that. That is my to-do list, because that is a huge question lots of people have. No mistrial or malicious prosecution. Right. And that's another great one, too. They requested a mistrial repeatedly, so over and over and over again. And then they had multiple pretrial motions as well for motions to dismiss. All of those, went through. So we're kind of in the check the post in your profile. Okay, I will do that. Let me do that. Let me write that down so I don't forget. So I think that's really good. Again, too, and you'll see that Todd Blanche, right after the verdict came in, asked for an acquittal. So, you got to do what you got to do. You got to make your record. You got to make sure everybody knows. Still in committee. I just don't know. I'm not sure. I'm not sure, Jennifer. I'll have to take a look. Travel restrictions can be waived by countries with proper requests and approvals. Yep, that makes sense. Sometimes you do lose. Absolutely, John. Absolutely. Yeah, that does make sense. Please clarify for the MAGAs here the not unanimous jury instructions. I'm really struggling to understand. Like, I know that there's somebody out there, giving you some crap information about these jury instructions, and I can't even understand what they're saying. Sorry, everyone, I'm looking right now for my jury instructions here. Hold on a second. One moment, please. So I kept trying to figure out, like, how do I explain this better, but where did they go? But I don't understand what they're even saying. It doesn't make any sense to me. I must have left them in my other folder. Sorry, everybody. I don't have the jury instructions on me. So, I don't get it. What's this unanimous? Why don't you tell me what's up? Tell me what's going on with that, everybody. What are they saying? Because I don't understand. It doesn't make any sense to me at all what's happening with that. Okay. Right. Okay. So, I did read the jury instructions. I just don't know where I put them. I was just looking at them a couple hours ago. So, of course, I probably just set them down somewhere. Probably my cat sleeping on them. Okay, the judge told the jury they didn't have to be unanimous on their charges. Okay, so, all right. Okay, I got it. So here's the deal. Everybody. here is, maybe this will help you. Here's the verdict form, all right? So when they came in, they had to fill out this verdict form. And I want to just make sure, yeah, we've got everything is, just making sure everything is private here. Okay, here's the verdict form. So they go in, they have their jury instructions, and I have gone through those jury instructions multiple times, and will continue to. But, so we've got the jury instructions, they go through and they decide what they decide. And then they're given this form, and it has 34 counts on it. And they have to decide on each count, guilty or not guilty, or guilty or not guilty. This has to be unanimous. The other decisions that they make on the other, 40 pages of jury instructions, it doesn't matter. That doesn't matter. They can, as long as they've read it and they're following the directions, whatever. But here's the deal. This has to be unanimous. They can't come in and say, oh, I don't know. Some people can't just say not guilty for some, and some people can say guilty for others. No. This is the form right here. This is the verdict. You have to say guilty or not guilty, and it has to be unanimous. So that's it. I mean, there's, I guess they're saying like, oh, well, some of them thought it was this, and some of them thought it was that, and it didn't have to be unanimous. Who cares? None of that matters. None of that matters. What matters is that we had 12 people, and you sat down at the table, and they said, count number 1, and they said guilty. Count number 2, guilty. Count number 3, guilty. So whether they felt it was, bad behavior for the election or, conspiracy between the three or whatever, it doesn't matter. As long as they decided guilty or not guilty, they have the, so these names down here, and I think it's okay to have these out here, that's why I didn't cover them, but these are the attorneys that were involved, as well as the clerk. So I don't think it's any big deal down here, but yeah, so we've got the ADA listed as well as the defense counsel. So counsel's name's what's listed here, and then we have the date, and then the 4-person's number is listed here. So yeah, Steinglass, and then defense counsel over here. Okay, so yeah, I mean, you have to pick your, well, and we talked about that a little bit. Boy, this would be easy if I had my instructions. Hold on, everybody, just a minute. Let me get it. I know that it's hard when you don't have your when you don't have your solid answers, it can be tough. So, all right, here are the instructions. Everybody, here's the instructions. So we had in here, let me give it to you this way. All right, let's do it this way. Confusing the instructions, didn't have to agree. Right. Okay, so, all right, let's talk about felony murder. All right, felony murder. That's not this case, but this is how I'm gonna explain how this works. All right, felony murder. So if somebody is homicided, all right, so let's do the homicide. This is a sad face. Somebody's homicide, all right? While you're committing a felony, you have felony murder. So it's not just murder anymore, it's felony murder. So let's say somebody gets run over, all right? So you run somebody over. So that's manslaughter, and they're done. But if they get run over because you were committing a felony, now we're at the highest level of homicide. So now we need to have a felony. So let's say you were look at felonies, forcible felonies. We had burglary, a robbery, all right, kidnapping. I'm just picking some felonies here. All right, and then we'll have, theft of $1 million, 1 million. So, well, let's pull theft out. That gets tricky. So here you go, kidnapping. All right, so here's the deal. So to the jury, we have a dead person, an unalived person, done. So the jury's like, yes. Now they've shown evidence for a burglary, a robbery, and a kidnapping, evidence for all three of those. So when they ask the jury, they don't say, well, you have to tell me it was a burglary or it was a robbery or a kidnapping. No, they just have to say one of these happened in order for you to have a felony. So now you've got a felony murder. Right? Yeah, no, it doesn't have to. So maybe 4 of them were like, oh, it's a burglary. And like 2 of them were like, oh, it's a robbery. And 6 of them were like, oh, it's a kidnapping. Like, it doesn't matter. What they do is like you pick 1, 2, or 3. And if everybody picks one of the numbers and then you add it to the homicide, you have felony murder. All right? Yeah. So that's the thing. And Todd Blanche, I thought, set it out pretty good, right? So we had this idea of, was there election interference? Was there some kind of tax, fraud? Was there some kind of other documents? Blanche said it in his closing statement. So here's our 3 crimes that he put out there. So in order to have a felony, you need to have a crime plus false documents or false writing. Okay, false writing. All right, that's it. That's how you need to have it. So over here, we just need a crime. It doesn't matter which crime it is. Like pick your crime. It's like pick your story, right? Was it an election issue? Maybe 2 of them thought it was an election issue. Fine. Maybe 4 of them thought it was the tax issues. Fine. Maybe 6 of them thought it was some other kind of documents that they don't even know. There's some other kind of illegal documents going on. So what did I say? 2, 4, and 6. The point is, we had 12 people that agreed a crime occurred, right? And then when you add that to false writings, then you have that felony. So now you've got an E felony. All right, everybody. So, you can pick your road. And some people are like, whoa, you should really specify if it was election or tax or documents. Like, okay, that's fine if you're in a state that requires that. But in New York, the law does not require you to specify what crime is afoot. All right? It doesn't say you have to talk and go through each one of the elements of each of the crimes. It doesn't say that. It just says there has to be a crime. And that's because that's how the New York law is written. So if you don't like that, if you don't like that they didn't set it out, then you've got to get a hold of the New York legislature. You got to call the senators. You got to call the House of Representatives because they're the ones that wrote the law. Yeah, they're the ones that, right. A road is a road, Murray. A road is a road. Right, exactly. Oh, my goodness. Right. Crimed in Florida. And he did crime in Florida, allegedly. So I can see why people are getting mixed up because they're like, oh, well, what do you do? Well, even, what's the crime? It's like, well, I don't have to tell you because according to New York, all I need is a crime. So, another way of looking at it, for those of you that have a better way of looking at it with the RICO, all right, if we look at the RICO, it just says that there is an enterprise, right? And there were overt acts. Now, it doesn't say what your overt acts are, but you have to have one or more, all right? And so in Georgia, we have 161 acts. All right, so all the jury needs to do is pick 2 out of the 161. Just pick 2, and we've got a RICO charge. All right, so pick your 2. So we've got a lot of choose your adventure here. But yes, so hopefully that can help a little bit here, and that's just because of how the law is written, and the law is written by the legislature. They wrote it. Wasn't it beyond the time allowed? Good question. No. No, it wasn't. No. So the writings that were made and all of that has a statute of limitations, and the statute was not. Trump officially a felon upon conviction, not until sentencing. So Shirley, great question. And, I have always believed when a jury finds you guilty, then you are guilty. So the jury found him guilty of felonies, so he is now a convicted felon. Now, is he a sentenced convicted felon? Has he already, served his sentence? Is he a recovering felon? I don't know. But as far as being convicted, the jury has convicted him. Plenty of evidence to support whatever crime. Oh, right. Pick your crime. Well, there is an appeal process, absolutely, and rightfully so. Everybody should have a right to appeals. What were the jury instructions? Well, you're looking at them right here. So it's over 50 pages. And what you can do is you can go online to the New York courts, and they actually have a special tab just for the jury instructions. So you can pull them up. Ooh, good question about the JAC order, Richard. I'm not sure. The last thing I saw was a paperless order getting mad at NADA. That's the last I heard on that. Does sentencing never need to happen prior to his appeal? No. Your appeal just has to be after the trial. So I'm sure they're working on the appeal right now. And if you're not appealing the sentencing, then you can appeal. If you're appealing something done in the trial, you can file that appeal. But if you're appealing what the judge sentenced you to, then of course you have to have a sentence. Yeah, and I've seen these statistics of winning on appeal, and quite frankly, it surprises me. I am surprised. Some people are saying you only have a 6% or 7% chance, and I'm just like, ooh, that sucks. I mean, I think it's because the judges just work so hard to make sure that there's not a problem. That's what I'm going to hold on to in my happy unicorn rainbow land. But if there's mistakes, they do get overturned. So I'll just live in my own land of deception, because that seems low to me. That seems very low. Time stops for the cases. Well, no, nothing stops in the criminal system. In July 11th, I think, is when it was going to go. Yeah, nothing stops. Nothing stops in the criminal case. It keeps on going. 7/11. Thank you, Richard. I appreciate that. Between now and sentencing, what does he have to do? Well, he still has his conditions of release. So he still, has to not violate any rules, and he has to kind of make sure that he's complying with whatever his conditions of release are at this point. He's also going to have to talk to whomever's in charge of the PSI, or the pre-sentencing investigation, or in order to do a pre-sentencing report. So the system sends out someone to talk to Mr. Trump and the peeps in his world in order to gather enough information to give to the judge in order to figure out what the most appropriate sentence is. He'll be drug tested. Well, most are. I think it's a requirement. He'll see a jail cell. No way to know. It's possible. I would say it's possible in this case. Can he still vote in Florida? I don't know. Florida, when it comes to Florida and voting and any rules in Florida, my best answer is I don't know, because things is crazy down there. New York has his passport. All right, there you go. Can you travel in the U.S. campaigning? I would bet so, yeah. I would say he's kind of he's special when it comes to traveling questions. So I would say that would be allowed. Let me see here, actually, everybody. Let me see if I can find that specific. What sentences have others gotten? Good question. Both Cohen and Weisselberg did get some time, but they pled. So I'm not sure if he would get less time because he was actually found guilty rather than actually pleading out. So that I don't know. Presumption of innocence, limiting instructions. Again, I'm looking for that, choose your adventure instruction here, everybody. Again, I've heard that it's like this big deal that, they didn't have to be unanimous. And I'm like, what are you talking about? That I cannot quite figure out what the brain situation is happening here. Oh my gosh. Right, so we talked about that. We talked about this. Intent to conceal, right, okay. Intend to commit another crime or to aid conceal the commission thereof. So all it says is another crime. It doesn't say, the instruction doesn't specify what crime it has to be. So that's what we're talking about here. We have to have a general intent and we have to have another crime. And that specific crime's not mentioned. And that's, that's done by statute. That's law. So that's not anything that the judge decides or the jury decides. That's all set. Yeah, the appeal process, this is going to be tough to appeal. In my opinion, I think the prosecution did a great job. I think when you have a judge this seasoned, he's not making rookie mistakes. This is just a muscle memory for him. So I don't know what would be, I don't know what exactly would be appealable here. I mean, if you want to appeal, go for it. Gag order violations, yes, there are. He's got 10 violations. That will be considered in the sentencing for sure. The judge was not pleased with that. I did go through and read those hearings, and the judge was like, dude, what do we need to do here? Like, the judge said, look, fines aren't going to be enough for you at this point. You keep violating, and the only thing I can do is put you in the slammer. He's like, I don't want to do that. I don't want to have to put you in the slammer, but what else am I supposed to do? That's the same judge that's in charge of his sentencing. So it'll be interesting. That's why I think that there's a possibility here that we could have jail. Ineffective counsel, sure, could. Is the gag order still in place? Well, yes. And the reason I say that is because there's no order that's dismissing the gag order. The gag order is a court order, and there was no termination language other than until the end of the proceedings. So, until the proceedings are done. And I would imagine sentencing includes proceedings, so is included in that. And I haven't seen a motion to dismiss it yet either. Does he have to stay in New York? Good question. That's a great question, and I'm not sure. I'm really not sure. Jail time because of the gag order violation. I think it will be a factor, but it will not be the only factor. The judge has to look to the totality. They literally look at all of the information that's pulled in, that's gathered, and the judge will go through it, and then he'll say, okay, he'll weigh it all out and figure out what he thinks is the best. Can you appeal based about whataboutism? Well, I mean, you can appeal anything. You can appeal a ham sandwich, John. You certainly can, but it doesn't mean the court will take the case. And the lawyer that appeals the ham sandwich might be in trouble. To further create false documents, a secondary crime. Oh, maybe. I don't know. That's a bit of a stretch. We like to kind of go with the easy route, even though it doesn't seem like it. We try to go to the easy route, push the easy button. Like, what's the easiest way to go about it? Like, pick out 3 or 4. Pick your crime, but not a crime that's difficult to define. DNA, yes, I think so. That should be in there. His DNA should be taken and then entered into a CODIS, I would imagine, as all felons have to do in the United States. Oh, the mods are amazing, aren't they? I know. Lawyer must be hungry when I eat the... I know, right? Judge will sentence him to a felon. Well, maybe. Tax evasion is probably going to be next. Could be. As we spoke before, I know that IRS has got, they've got open files. They've got filing cabinets. What happens if the New York Appeal Court doesn't take it based on merit? Well, if your appeal is rejected, then it's done. That's it. If the higher court says there is no grounds, it would just be like cert being denied for the U.S. Supreme Court. They're like, look, we deny cert. There's no grounds here for us to take it. So that means the case is done on that issue of appeal. So you have to keep in mind, whatever issue of appeal, and you can have 100 different issues. And so they have to decide for each one that's being pled. Can he even leave the United States? I think there might have to be some kind of accommodation made, is what I would imagine. Can he appeal a denied appeal? That's a great question. I guess you can. I'm not sure exactly how that would work. So if you appeal, typically what happens, all right, everybody. All right. All right, typically what happens, all right, is that let's just do a visual here, all right? Oops. 3 comes after 2. 4, 5. We'll just go with 5. So I've got 5 issues on appeal. All right, I got 5 issues. I'm going to bring three of them in one motion. One motion to appeal has three issues. My other two issues I'm going to leave on the back burner. So I file my motion to appeal, and this is rejected. The court says we are not going to listen to your appeal. Rejected. All right, so you're like, shucks, those three issues, dang it. The way that they were phrased, the court rejected it. So these are out. So now I'm going to find another motion on these other two issues of appeal. All right, and then let's just say these are rejected. And you're like, oh, shoot. So then you go back, and you pull out, and you do your third motion. All right, and it just is the song that never ends. So yeah, so that's how it keeps going. Yeah, but if we had this rejection here, if they're like, "Nuh-uh, you should take my case," no, you're not going to be able to come back in. If the court has determined you've got a jurisdiction, or they don't have jurisdiction, or that they don't have an appealable issue, I suppose you could appeal that. Come to think of it, we have had motions for summary judgments appealed and so on. I suppose you could, but what special protections is this judge and jury going to be given? I'm scared. Yeah, me too, Kim. I don't know. It's whatever they've got in the books on how to protect those people. I mean, I really don't know. What is New York going to do? It's really a government question. Can you appeal to the Supreme Court? Well, it's a state case, right? So here we've got trial court. He'll be able to appeal to, I don't know what they call it the Supreme Court, and then they've got like some kind of, I'm going to read, this isn't the correct name, everyone, in New York, and then they've got their Supreme Court, but this is the wrong name, but this is the state. All right, so you have a state court, you're like, I don't like it, I'm appealing, Court of Appeals is like upheld, and then the Supreme Court's like upheld, and then it's possible to move it over to SCOTUS, but only if you've got some kind of constitutional question or some other kind of, issue that's going on with it. How does the cycle ever end? Well, I think you get to a point where you can just keep doing it, honestly. I mean, how many appeals have there been for, some of the people that have been in jail for decades? They continue to appeal. Keep going, like, oh, I found new evidence, like Peterson. I think we just talked about that. Scott Peterson's like, ooh, new evidence, or, ooh, DNA finally got tested. Like, let's bring the case, like, whatever. It can just kind of keep going on and on and on. Thanks for you. Oh, you're welcome. It seems, I'm not trying to make it sound negative, everyone. I'm just saying, it goes on, and it just keeps going until finally until you reach the end, the last court in your jurisdiction. What happens in the meantime? Well, you just keep going. He has to show up for sentencing. Once he's sentenced, he has to fulfill his sentence, and then there you go. You just keep walking. You keep walking down the road. Yeah, it is just reality, exactly. Just how it works. Any issue will be a federal issue. I can't either, sweet. I can't see any issue. If they somehow found that this section of the New York law was unconstitutional somehow, I don't know. I mean, that's all I could think of. Yeah, he's in jail. I mean, you keep going. You don't get paused. You don't get paused out of jail, while your appeals are going. No, like you could be sentenced, serve your sentence, be out, be at home with your family for 5 years, and then be granted your appeal. I mean, it can just keep going on and on forever. So you can still run for, well, yeah. I mean, of course, because Article 2 just sets out just like 3 requirements, and that's it. If you meet 3 requirements, then you can run for president. You too can run for president. I can run for president. I mean, it doesn't matter if you're qualified or not. Because, that's how it's worded. Yeah, 30 days in prison, house arrest could be. Tea break, thank you, Desert Skies. Oh, good point. Right, and who knows if he would vote for himself anyway. Like, I mean, does he even vote? Come on. Jury keeps the instruction. No, juries don't, they didn't even get the instructions, actually. They had to have them read back to them, like New York, that's hardcore. Can you run? No, thanks, Thomas. No, thank you. Not where I live. I don't think so. No. I'm in the red weeds. That would not be good. Oh my goodness. Yeah, no. Why didn't they? I don't know. It's apparently that's just how they do in New York. They just don't give it to them. And I guess many jurisdictions do that too. I mean, every jurisdiction is a little bit different. They run their rules based on what works for them. And in New York, you just don't get it. What's the deal with him? Yeah, I don't know. Well, it's okay. I mean, it is what it is. And if people want to be red weeds, then they can. That's fine. Can the judge postpone a jail sentence until after the election? Yeah, but I'm not sure why. But he could, I suppose, technically. I can't remember the name of the woman who had like grifted all that millions of dollars saying that you could get your based off of the blood sample, it could like tell you exactly what you're allergic to or if you had any kind of like genetic problems. I can't remember that woman's name. Forgive me, everyone. But she was like a billionaire and she found out that she grifted. So she was found guilty. Thank you, Elizabeth Holmes. Oh my gosh. Thank you so much. Right. So Miss Elizabeth Holmes was found guilty, but it was coming up on the holidays. I think it was in October or November. And the judge said, we can just wait until after the new year. So thank you so much. Was it Theranos? Okay, Thanos. You know what I'm saying. You know what I'm saying, right? So this lady whose name escapes me, jury asked for the instructions several times during deliberating. Yes, they did. They did. And I do have the transcripts of that. I do plan to read those transcripts. That's kind of on my list. I will continue to read through the transcripts, everybody. I do want to finish up Mr. Blanche's because I think it's really important. I think it's important to kind of hit the talking points that are hitting the news right now. I think it's helpful. Oh, with Walgreens. Okay, fair enough. That's right. It's starting to click again. It's hard to keep all these cases straight, everybody. Elizabeth Holmes. Okay. All right, there are consequences. Right. Yes, frivolous appeals. Yes, and that's possible. You can get into trouble for frivolous appeals. Absolutely. But then again, you don't have to have an attorney to file an appeal necessarily. So, but you can still have you can still, as a person, as a pro se, get a frivolous appeal, get you burned for that too. So they decide, oh, absolutely. So, right. So I will be coming back, everyone. I will be coming back. I've got more of the closing statements to do. I've got more of, I want to also do the state's closing statement as well. Plus, we do have the transcripts from the last day with the jury coming back and the questions that were asked. So I do have plenty of material to take everybody through, and I probably will just have that as my lives for the next little bit here to just make sure everything kind of needs to calm down a little bit again. Oh my gosh, was the one he found himself? Well, I mean, yeah, you absolutely can, and should, if that's what you think is best for your case. So anyway, I will be coming back. Now, I won't be back again today, everyone, just because I usually don't come on Saturdays, but I'm always back for my Sub Chat Sunday on Sunday nights, 7 o'clock. So I will be back, and then this whole week I should be back to my regular programming where I'm on at 7 o'clock Central. So I will be, there is like an alert. I think there's a button you have to like click in order to get notifications. So yes, Secret Service. That's so funny. Ooh, that reminds me, I got to look that up too. Yes, very interesting. Yes, well, he's got 3 other trials. Right. Happy Pride to you. Yes, exactly. So I am keeping my eyes on those as well, everyone. So Florida, I think, is probably going to hit the fan pretty soon. And then I think DC, once that immunity case comes down from SCOTUS, will hit the ground running as well. So we'll have motions flying there as well. I will keep you up to date, everybody. And I will be back for sure tomorrow, 7 o'clock. I'm not sure I'm going to have time before then, but thank you all for joining me, everyone. I will go ahead and sign off for now. But it was great to see you all. Thank you all for hanging out. And like I said, I will be back again, and we'll kind of continue to go over these closing arguments, and we will continue to go through these transcripts. So take care, everyone. Have a great rest of your day.